More student loan shenanigans coming out of the Department of Education, and it may impact your student loan payments. So let's talk about it. You may have heard that as of May 2025, the Department of Education is going to be using your spouse's income to determine your student loan payment under any of the income-driven repayment plans, even if you file separate federal income tax returns. So is it a punchy headline designed to scare you, or is it really happening? See, this all stems from a federal appeals court injunction against the SAVE plan. When that ruling was issued, the government shut down all IDR plan applications to comply with it. The American Federation of Teachers sued to get them to reopen the application process, and the government told the court that they expect servicers will be able to do so by May 10, 2025. Great news, right? Well, not so much, because the government also said that they're going to start using spousal income to determine payments under ICR, pay-as-you-earn, and IBR, even if a married borrower files separate income tax returns. And they claim that they're doing it because it's required under the injunction. Now, to determine whether this is legally allowable, we need to discuss IBR separately from other plans, because IBR has its own separate section of the law. Under the IBR statute, if a married borrower files a separate federal income tax return, the Secretary of Education shall calculate the borrower's IBR payment solely on the basis of the borrower's student loan debt and adjusted gross income. In other words, a spouse's income is excluded from consideration if the borrower files taxes separately. Conversely, the IBR calculation uses the combined income if a married borrower files jointly. Now, the ICR statute, however, is a little different. That statute, which was used to create income contingent repayment, or ICR, pay as you earn, and SAVE, says that the repayment amount shall be based on the adjusted gross income of the borrower, or if a borrower is married and files a federal income tax return jointly with the borrower's spouse, on the adjusted gross income of the borrower and the borrower's spouse. But it doesn't explicitly prohibit the use of spousal income. In fact, the statute also says that the government shall require payments that vary in relation to the appropriate portion of the annual income of the borrower and the borrower's spouse, if applicable. See the difference? Under IBR, the monthly payment is calculated solely on the borrower's adjusted gross income unless they file a joint return. The ICR statute, however, doesn't limit the calculation the same way, which is why the government was able to count spousal income for separate filers when it created revised pay-as-you-earn in 2015. And of course, revised pay-as-you-earn is what ultimately became the SAVE plan. So to align how IBR and ICR counted spousal income, the Department of Education included in the SAVE plan regulations the ability for married borrowers who file separately to exclude their spouse's income. But with those SAVE plan regulations off the table, the government says that the federal appeals court directed it to count spousal income for married borrowers even if they file separately or are separated, even for IBR, which is wild because in the case of IBR, counting spousal income is against the actual text of the law. So what's likely to happen here? We can expect either a court ruling or a separate lawsuit that prevents the government from using spousal income to calculate IBR payments if you file separately. And I'm reasonably confident that borrowers are going to win on that count. For ICR and pay-as-you-earn, however, it's a different story. I think the government's actions are going to be seen as allowable under the law, but even that is going to probably trigger a bunch of lawsuits as well. Either way, this isn't the end of the lawsuits. As always, I'm going to keep you updated, not with headlines, but with accurate information. And if you've got any questions about your federal student loans, your private student loans, or any debt whatsoever, as always, you know where to find me.